Welcome back to the channel. Today we're diving into a powerful Senate exchange where a professor is grilled on one of the most debated topics in constitutional law, original public meaning. What does it really mean? How does it connect to landmark cases like Brown versus Board of Education? And what role do amendments in legislative history play? Let's break it all down. The senator starts by asking the professor to define original public meaning. His answer: it's the way the public understood the text of the Constitution at the time it became law. In short, not what we think today, but what people thought back then. This sets the stage for a tough line of questioning.
Professor, congratulations. I believe you testified that you think the Constitution should be interpreted according to its original public meaning. Is that right?
Yes, Senator.
What does original public meaning mean?
Yes, Senator. So the original part of that phrase refers to the fact that when we look at interpreting a text, we want to interpret it at the time it was.
Professor, look me in the eye and just answer my question. What does original public meaning mean?
It means the meaning that the text as it was understood by the public at the time it became law.
The senator immediately presses the issue. If we follow original public meaning, was Brown versus Board of Education wrongly decided? The professor defends the decision as correctly decided, though he admits scholars debate whether its reasoning aligns with originalist theory. Here the tension really builds. Could the public of that time have possibly supported integrated schools?
Okay. So you think Brown v. Board of Education was incorrectly decided?
Well, Senator, I think Brown versus Board of Education was correctly decided. Scholars who have looked at the original meaning of phrases at that time and the reasoning in that case sometimes question the reasoning of the case.
How many people in the United States of America at the time the Constitution was drafted do you think supported racial integration of schools? You think that was a majority view, do you?
Well, Senator, at the time...
But first, Professor, do you think that was a majority view? Do you think most Americans at the time the Constitution was drafted supported integration of public schools, racial integration?
Well, Senator, I don't know as a sociological matter what percentage of people thought what at that time. I should point out that when we got to Brown versus Board of Education, of course, there had been several fundamental amendments to the...
But isn't that inconsistent with your statement that you have to interpret it according to original public meaning?
When cornered, the professor leans on the 13th, 14th, and 15th Amendments. He argues these amendments clearly demanded racial equality, even if society wasn't ready for integration at the time. He explains that constitutional principles evolve through application to new issues, meaning equality under the law eventually had to include schools.
What about the 14th Amendment and the 13th Amendment and the 15th Amendment? So original public meaning would mean with those... Well, that would mean we would interpret those amendments and those protections with the understanding of the text and structure at the time those amendments were ratified, which is different, of course, in the 19th century.
Let's go back to Brown v. Board. Look, I think Brown v. Board was correctly decided, and I suspect you do too. But if you say we interpret the Constitution according to the way that people at that time understood it, do you really think that people at that time in America supported racially integrated schools? Do you really believe that?
Well, Senator, I think at the time of the ratification of the 13th, 14th Amendment, and 15th, all which have...
But do you think people at that time supported integrated schools?
Well, Senator, on that particular question, I don't know it as a policy matter whether they were thinking about that particular issue. I think they certainly understood that the 14th Amendment, for which a massive part of this country essentially lost lives fighting the Civil War, certainly understood it to require racial equality.
You're not answering my question. I'm just trying to understand how you think. It's very easy to say, we interpret the Constitution according to its original public meaning, which as I appreciate your testimony, means the way people who read the Constitution at that time interpreted it. Is that right?
Yes, Senator.
Okay. Do you think that most people at that time looked at the United States Constitution and said, well, here it is, big as Dallas, racially integrated schools are required. Do you really believe that?
Senator, I don't know, but
And if you don't, I don't think you do, because I think historically that wasn't the case. So how do you square that with the holding of Brown v. Board?
Well, I guess what I'm trying to say is I think there are several steps in between that have not come up yet in our conversation, which is that you look at the text and structure, which of the 13th, 14th, and 15th Amendments clearly is requiring racial equality. And then over time, that has to be applied to different questions as they arise in context. So if the requirement is that all races be treated equally under the law, and the evidence shows that segregated schools is not doing that, then the requirement could be applied to integrate schools.
The questioning shifts to how judges interpret statutes. The professor says the process always begins with a plain text, then moves to surrounding provisions. But what if the law is ambiguous? He points to the Supreme Court's Chevron precedent, which requires courts to push for an answer instead of leaving ambiguity unresolved. Quick pause here. If you're enjoying this breakdown, make sure to hit that subscribe button so you don't miss future deep dives into politics, law, and history.
When you interpret a statute, you talked about interpreting it according to its plain meaning. What if the statute is ambiguous?
Well, Senator, if the statute...
What do you do if it's ambiguous?
If it's ambiguous on the particular question coming before the court, I start with that phrase, but I also look at the context of surrounding provisions.
No. How I understand you define ambiguity as the language plus the surrounding language.
Yes.
I get that part. How ambiguous does it have to be? 51% ambiguous or just a little bit ambiguous?
So I have to say I would use the same approach essentially in all cases regardless of the ambiguity, because I would always start with the text, move to the surrounding provisions with the aim of fully understanding what Congress and the President had enacted. And only at that
Professor,
point...
I'm going to run out of time. With respect, answer my question.
Well,
okay, you're giving me professor talk. How ambiguous does it have to be?
I mean, I think under the Supreme Court's recent precedent in Chevron, it underscored that the court can never just rest and say it's ambiguous. The court has to come up with an answer.
Finally, the senator challenges her on legislative history. Should judges use congressional records and committee reports to interpret statutes? The professor responds carefully. Legislative history can provide useful context, but should never be treated as legally binding by itself. In other words, it's a piece of the puzzle, not the final word.
Yeah.
So
why don't you just look at legislative history?
Well, you can't look at legislative history statements one by one because the individual intent. Well, Senator, with respect, because this body has its role in our system as an institution, not one by one. So your personal understanding of the law doesn't matter.
This will be my last question. I'm sorry. Coons went way over. So you're telling me that it doesn't help you at all to go through and look at the congressional record or read the committee reports or any of that? You don't think that's helpful in interpreting what a statute means?
It depends on the way in which it's being read. If it gives helpful statutory history, if it helps to refer to other portions of context, sure, but not to give it legally binding impact in and of itself. I would always be looking at a broad range of sources and use each of these statements as just one piece of evidence about what people understood the statute to mean at the time. So no, I would never take a piece of legislative history in isolation and give it legal impact.
Thank you, Madam Chair.
Thank you.
This exchange shows just how complex judicial interpretation really is. On one hand, there's the push for original public meaning. On the other, there's the practical need to apply constitutional principles to modern problems. The professor's answers highlight the delicate balance judges must strike between history, text, and evolving issues. Thanks for watching. Drop your thoughts in the comments. Should courts stick strictly to original public meaning, or adapt more openly to modern values? Don't forget to like, share, and subscribe for more in-depth breakdowns.